Alrighty.
We're recording.
Great. Thanks, Mia. So welcome everyone to our second and final paid family leave training. This is so exciting and glad to see everyone back here again. And to start us off again this week, I'm going to pass it off to Raina.
Okay, I'm on my phone. Can everyone hear me?
Yes.
Perfect. Hello again. I'm Raina Granberry, pronouns she, her, they, the Perinatal Equity Initiative Coordinator at DPH. And if you all remember anything from the previous session, where a state grant that was given to the county to work on all matters in African American infant, maternal, and mortality prevention. So like before, if you could just in the chat, put your name, your pronouns, your organization, and your workplace, that would be appreciated. If you're an individual, just represent yourself or put what neighborhood you live in. That'd be helpful as well. And the AIMM initiative and the AIMM CAT is our county collective of the health agencies, birth workers, community organizations, service providers, allies, funders, friends who all come together to work on this issue of disparities. And we're just really happy that you are here. This isn't just something that we feel is a nice thing to do. It's actually evidence-based and proven that when folks access what is available to them and what they've paid into and what is rightfully theirs, they do have better outcomes, and that is what we're all about. So I appreciate our collaboration with the California Work and Family Coalition, and I will turn it back over to them.
Thanks, Raina. So we are the California Work and Family Coalition. My name is Charlotte Flanders. My pronouns are she, her, hers, and I'm the Education and Training Manager. Jenya.
Hi, everybody. Happy to be here. My name is Jenya Cassidy, and I'm the Director of the California Work and Family Coalition.
My name's Katie, really excited to be here with you all as well. I'm Political Organizing Director. My pronouns are she, her.
And Angelica helps us out with the morning training, so she's not here this afternoon, but she's our admin assistant and Spanish training coordinator, and then Mia.
Hey everybody, I'm super happy to be here. Thanks for coming to session 2. My name is Mia, my pronouns are she, her, hers, and I'm the communications manager here at the coalition.
And just like last week, we have our partners Legal Aid at Work here with us today. Katie, do you want to introduce yourself?
Hi everyone, my name is Katie Witchett, pronouns she, her, and I'm an attorney at Legal Aid at Work. Happy to see you again. As background, Legal Aid at Work, we're a nonprofit that focuses on workers' rights. And then my team specifically, we focus on the rights of families. So their ability to be there for each other during times of health crisis or during pregnancy and times of transition with new children, and how to make sure they can keep getting their pay and keep their job safe, get accommodations if they need them during that time. So we do education, but
Katie, I think you froze.
But also advocate for better policies. Can you hear me now?
Yes.
Okay, I turned off my video. Hopefully I can bring it on later, but just to make the internet a little bit better. But I was just wrapping up by saying we offer free one-on-one legal advice and tips for people who have questions about their rights to leave or how to address it with their employer. Thanks.
Thanks, Katie. And Jenya, do you want to talk about what we do as a coalition?
Yeah, thank you, Charlotte. So the California Work and Family Coalition, we're a statewide alliance of a lot of diverse organizations across California, and we're all united in the belief that all people should have the time and resources to care for themselves and each other. We came together around the very first, passing the very first paid leave law in the country Back in 2002, California's paid family leave, which people have been taking since 2004. But since then, we've been really working on a lot of the different changes to the law that we've needed to really make it work for everybody. Because even, passing the laws is one thing, but a big part of what we do is what we're doing here today, which is doing community education and how we access these laws. So we are working on organizing, advocacy, and education. And yeah, that's what we do. Thanks.
Great. So for today's training goals, we're going to review the leave laws that we talked about last week. We're going to understand paid sick and safe days and learn how to apply the knowledge that we've learned to some scenarios. Unfortunately, the Earned Income Tax Credit Program was not able to join us today, but I will follow up with some resources regarding that. So for our meeting agenda, we are going to start with a review, go into some practice scenarios, learn about paid sick and safe days, talk about the paid leave checklist as a resource, and then go into some Q&A. And throughout this time, if you have any questions, feel free to put it in the chat. Katie from the Coalition is here today to gather those questions, and we can answer it during the Q&A session. So let's get started.
Hey, everybody. Can everybody hear me? I can't see anyone, so shout it out.
Sound good, Mia?
Okay, great. So today we're going to be doing a quick review of paid family leave and disability insurance. Some of y'all will remember what we talked about last time, but just as a refresher, paid family leave and disability insurance are both wage replacement programs funded by the California State Disability Insurance Fund, which is funded through your tax dollars, right? Employee taxes go into this fund that we draw from when we need to take time off. The qualifying reasons that you would that would enable you to use paid family leave or disability insurance are if you're pregnant and you need to take time off due to your pregnancy, if you're dealing with a short-term disability, if you are caring for a family member who's seriously ill, if you're bonding with a new child, or if you're dealing with a military exigency. So again, think of paid family leave and disability insurance as two parts of the same whole. There are two programs paid for by employees, and it's all administered through the California State Disability Insurance Fund, or paid by and administered by the EDD, which is the Employment Development Department, which is the agency where you file your claims, and they also are responsible for sending you your money when you are taking this paid time off. So another visual for you to understand is when you go to the Employment Development Department to file a claim, they have disability insurance claims and paid family leave claims. So again, it's all from the California State Disability Insurance Fund, but for clarity's sake, when you're going on to apply or file a claim, know that you would file a disability insurance claim or a DI claim if you need to take time off for your own serious illness or disability, or if you need to take time off due to a pregnancy-related disability. You would file a paid family leave claim if you need to take time off due to preparing for a military exigency, right? Like arranging childcare or getting your family matters in order before someone is deployed. You would file this claim if you need to bond with a new child, and that child can be biological, foster, or adopted. Or if you need to care for a seriously ill family member, you would file a paid family leave claim for that as well. So here are the basics of these two programs. They offer you 60% or 70% if you are considered low income of your normal weekly wages, up to $1,357 per week for up to 8 weeks. This rate will potentially go down to 55% by December 31st, 2021, unless we advocate for it to stay the same or to increase. And we at the Coalition are advocating for it to increase this year. And so I invite you to go to workfamilyca.org/advocacy form, and we will send this link in the follow-up email if you are interested in advocating for this wage replacement to not go down and for it to increase this year. And I also want to note that this leave can be taken all at once or in parts. It can be taken hourly, daily, or weekly. So what are the eligibility requirements for paid family leave and disability insurance? Number one, you need to be paying into the California State Disability Insurance Fund. You can verify this by looking at your pay stub. You will see in the taxes withheld section, the CASDI, or California State Disability Insurance tax. And if you have money going out in that tax, that means you are paying into this fund. You also need to have a qualifying reason, which I talked about earlier, and that is to bond with a new child, caring for a seriously ill family member, needing to care for your own illness or disability, or to prepare for a military exigency. You also need to have earned at least $300 from which SDI deductions, the state disability insurance tax, was withheld during the base period. So you don't need to have paid $300 in taxes, you need to have earned $300 from which that tax has been taken out. In regards to what the base period is, Katie Witchett from Legal Aid at Work does a way better job at explaining that than me. But essentially, you don't need to stress too much about that. I know I didn't when I applied for paid family leave. I just filled out the form and applied and allowed EDD to make the determination of whether I had paid enough at whatever period. But it is something that's worth knowing, and Katie Witchett can explain more about the base period later. So 2 important things to remember is that citizenship and immigration status do not affect your eligibility of paid family leave benefits and state disability insurance benefits, right? As long as you're paying into this program, you have a right to it. I will say, though, that if you are undocumented or you have immigration concerns, it's highly recommended that you connect with a lawyer. So you can connect with one of our amazing lawyers at Legal Aid at Work, our partners, and let them know that you have immigration concerns, and they can help you apply for this leave that you are rightfully due in such a way that won't cause any issues in the future if you are working on, becoming a citizen or what have you. So definitely check with a lawyer and, allow them to help you apply for EDD. So another thing that you need to be aware of is that paid family leave is a wage replacement program only. It does not require your employer to give you your job back when you return from leave, right? That's what the job protection laws cover. And Katie Witchett will explain more about job protection.
Great. Thanks, Mia. So the 3 main laws that we'll talk about that cover the ways that your job can be protected depending on which reason you need leave are the Family Medical Leave Act, the California Family Rights Act, and Pregnancy Disability Leave. So I want to take this one slide to talk about the FMLA and the California Family Rights Act, because I know the FMLA is something that a lot of us have heard of. Like, it's out there, people take FMLA, they know what it is, employers who have a national presence know about it. But it's basically the federal version of the California Family Rights Act. And the California Family Rights Act it's better. It protects more people and it allows you to take more time off from work. So when we talk about this, I'm going to be focusing on the California Family Rights Act and on pregnancy disability leave, because although the FMLA is its own law, basically it overlaps with the other 2. So unless someone who you're talking to is a federal employee, there's not actually going to be a circumstance where the FMLA would let them take more time off than they're already getting from pregnancy disability leave or the California Family Rights Act. So the California Family Rights Act doesn't cover everyone, but it covers any employee who's been at their job for at least 1 year. And in that year, they've worked at least 1,250 hours prior to the time that they start their leave, which is about 25 hours a week. And their employer has 5 or more employees. Not too long ago, it used to be 50 or more employees, although now it's been lowered down to 5 or more employees starting in 2021. So it's a really good thing to know about, because there might be some employers who aren't aware of it and might, tell their employee they don't qualify just because they're not aware that the law changed. So for the reasons that somebody can take time off under the California Family Rights Act, it can be to bond with a new child. So that can be a child that is newly born, recently adopted, or recently fostered, and it can be used anytime within 1 year of when that child enters the family. It can also be used to take care of a seriously ill family member. So that can be a child, a spouse, a domestic partner, parents, grandparents, grandchildren, or siblings. This is another thing that changed recently. It used to only be that you could take this time to take care of a parent or a spouse or a minor child. So the fact that grandparents can take time off to take care of their grandchildren who are ill, and that siblings can take time off to care for each other, those are also new things. So it's good to be aware of that. Another reason somebody can take this time is for their own serious health condition. So if someone cannot work because of their own health, this is the law that tells their employer, okay, you absolutely have to hold their job for them. You can't hold it against them. They get to come back afterwards. And then finally, another more recent expansion is to cover situations where someone cannot work because they are dealing with responsibilities that arise from a family member's military deployment overseas. So like arranging for childcare. So as far as what these laws provide, they offer 12 weeks of job protection. So it's 12 weeks that you can take off and your job is safe. Your employer can't hold it against you. It can't negatively impact your job performance or your ability to be promoted. They don't have to pay you, but they do have to hold the job so that when you come back, it's as though you were never gone. And it can be used all at once, but it can also be broken up. If it's being used to take care of somebody who's ill or for somebody's own health condition, you can break it up any way that the healthcare provider says that you need to break it up. So, sometimes somebody will have let's say serious asthma, and they don't necessarily know when they're going to need time off. But they could bring in a note saying, okay, up to 3 times a month, my doctor thinks I'll need, 2 to 3 days off. And you can have something like that for your employer so that when the occasion comes up, they're ready. As far as taking time off to bond with a child and breaking that up, an employer can require someone to use it in increments of at least 2 weeks at a time. You get 2 freebies where you could take it for a day and you could take it for another day. But the third time that you ask to take it for a day, your employer could say, okay, either take 2 weeks or don't take it at all. During this time, your employer has to continue health benefits. So if there's if they pay into health insurance for you, they have to keep paying that in. If there's part that the worker usually pays out of their paycheck that goes to health insurance, the employer can ask the employee to pay that. But whatever the employer was contributing before, they have to keep contributing it the same. And then no discrimination or retaliation. So it's neutral. Your employer is supposed to act as though you never took the time off. So pregnancy, disability, this is another really important protection. And this is one that's unique to California also. So what it does is it allows someone to take up to 4 months off while they are disabled by their pregnancy, childbirth, or a related condition. And what that just means is if there's any time that a healthcare provider says, okay, because of your pregnancy, because of postpartum depression, because of complications, you're not able to work, your employer has to hold your job for you and to let you take that time off from work. So it can be all at once when someone has a baby and then afterwards while they're recovering from childbirth, but it can also be broken up. So it could be used for a prenatal appointment or, severe morning sickness. Or, maybe somebody goes back to work and then they have some additional postpartum depression and they need to take time off later. It's just dependent on whatever the healthcare provider says that person needs. A great thing about this protection is that it applies to anyone who works for an employer with at least 5 employees. So there's no tenure requirement, there's no hours requirement. You can have started a job yesterday or work only 5 hours a week, If you're an employee, you have the right to these 4 months off for pregnancy as long as your healthcare provider says that you need it. So because it's limited to when a healthcare provider says that somebody needs this time off, most people are not going to be disabled for 4 months. In a typical circumstance, any healthcare provider would say that somebody is disabled 4 weeks before they have their baby, and 6 weeks after for a vaginal birth, or 8 weeks after for a C-section. But one thing that I think it's always important to remember is that because this time is tied to the person's health, it's not like you can save it up to take more after. So, I talk to a lot of moms who want to spend as much time bonding as possible. And they're like, okay, I'll work up until like the week before, the day before I have my baby, if that means I get to spend more time with my baby. But because this is only available for when, because of your health, you cannot work, it doesn't actually give you more time off afterwards. So, whether somebody takes a week off before they have their baby, or 3 days off, or 2 weeks, it doesn't mean that they're actually going to be disabled by recovering from childbirth for a longer period of time. So if you're talking with a mom, I think it's always important just to encourage them that it's not 4 months to take whenever you want. It's 4 months for when you cannot work because of your health. So if your healthcare provider is saying, hey, you need to stop working, you can listen to your healthcare provider, and it's not going to impact the amount of time you can spend with your baby. So I also want to take a moment to talk about lactation accommodations. So all across the country, workers have the right to a private space that is not a bathroom to pump milk. It has to be somewhere that's safe, no hazardous materials, and the employer has to provide them with the amount of time that they need. So there's not like a set amount of time that an employer has to provide, and that's intentional, because the idea is that everybody's a little bit different and everybody might need a different amount of time. So they don't want to say, okay, everybody needs 15 minutes, because then if one parent needs 20 minutes or 30 minutes, they might get in trouble. So however long somebody needs, their employer has to provide it. And so this is one of the laws that is also different in California and also new, in that the room that's being provided has to have a place to sit. It has to have a surface that you can place a pump on, and there has to be access to electricity and running water nearby. So employers have been required to provide a space for a long time, but the fact that it has to have a place to sit, a place to put a pump, access to electricity, those are all new things, I think, since 2019, maybe. So some employers might also not be aware of it, but it's another, exciting development, so that employers can't put people in the supply closet like they used to do. That's against the law. So as we were talking about, there has to be access to running water as well as refrigeration. And so one of the important things is that employers have to have a written lactation accommodation policy, which is good, because it's something that some employers, they just don't think about, and it's their job to think about it. It's not up to the employee to have a plan and to be the one to establish what this will look like and educate their employer. Their employer is supposed to have a policy. So if you're talking to somebody who's pregnant, it's a good idea for them to ask their employer about that policy, because that way, if they don't have it, they can take some time to fix it and get a policy in place before the person's going back to work. And it's not this last minute scramble when somebody comes back to work and they're like, okay, I need to pump. And the employer's like, pumping, what's that? Because that's not good for anybody. And I want to mention, Raina added in the chat that the electricity is one of the things that employers forget. And I think that's true. They don't always take into account that a pump needs electricity, but that's something that the employer has to provide. So whether it's available in that room or they have to run an extension cord to it, it's their responsibility. There is one exception, which is that if an employer has fewer than 50 employees, if they can show that it's difficult for them to provide the space, and it's not just like a little hard, but like it would, like damage their business to have to provide the space, they might be able to get an exception from it. But, employers should be able to find a way to do it. It doesn't have to be a permanent space. It can be a tent. It can be something curtained off. It can be using a manager's office throughout the day whenever they need it. So it's good to know about that, but it's never on the employee to tell their employer they don't have to provide it. They can ask for it, and then if the employer says it's too hard, that can be a conversation that comes later.
Great. Thanks, Katie, for all of that review. So I thought now we can go into a few scenarios, apply what we learned. So the first scenario is with Lennar. Lennar and his partner, Julia, are expecting a baby. Lennar has worked for his employer for 7 years. He works about 30 hours per week and has about 25 coworkers at his job. He looked at his pay stub and he saw that CASDI, California State Disability Insurance, is removed from his paycheck each pay period. So based on the information we know, just go ahead and put it on the chat, your best guess. Does Lennar qualify for paid family leave for bonding? And will he qualify for job protection? Yeah, I see a yes. And if you don't know, that's okay. We're going to cover it on the next slide. I see many yeses. This is great. Next slide, please. So yes, great job. So yes, Lennar qualifies for paid family leave for bonding because he pays into CASDI. So this means he can take up to 8 weeks of paid family leave for bonding, either all at once or in parts, with his new baby, and can receive either 60 or 70% of his pay. And he does qualify for job protection under Cifra because he needs to take time off to bond with his new baby. He does meet the 3 requirements of he works for an employer of 5 employees. He's worked for more than a year and works more than 1,250 hours a year. So this means he can take up to 12 weeks of job protected leave to bond with his baby. And like we said, the review of the Cifra rights, 1 year on the job, 25 hours a week, and with an employer with 5 or more employees. And just to visualize this real quick, before we go into this visualization, I saw that there was a hand up. Kim?
Yes. Yes, hi, it's Kim. Just a quick question. So
Yes.
it showed me a poll question and it mentioned domestic violence. And that's really a concern of mine. I do work with domestic violence survivors as well. So does this apply?
Oh, no. The poll question is for actually later.
Oh, okay.
I don't know why it popped up. I'm so sorry.
Oh,
That is
that's
one
okay.
where you talk about paid sick and safe days. So
Oh,
thank
okay.
you for asking. No,
Yeah, no
so
problem.
sorry.
Okay,
Yeah,
I'll wait
thank
for
you for a
later.
question. Yes,
Yeah.
yes, definitely. But no, so that is definitely not for now. We're just covering FMLA, Cifra, and job protection. So sorry about that. Okay, so just a quick review, going back to Lennar. And also, if you don't know these answers, that's completely fine. You know, this is why we do a lot of reviews. Just test yourself. So for this visual, for a bonding parent that is eligible, right? And like I said, parents can take this all at once or in parts, very much up to them. But for Lennar's scenario, let's just assume he's going to take all the 8 weeks. So when you see at the bottom, that is job protection, and at the top, the green, that is the wage replacement part. And I want to show all of you how these laws work together. As we know, Cifra is really technically unpaid, and the paid part of it is when paid family leave comes together. So for the 8 weeks of the 12 job protective time off, he gets 60 or 70% of his pay. Now, as you see, there is a remainder 4 weeks that is unpaid, and that is very much up to Lennar if he wants to still utilize that time to bond with his baby, or if he wants to go back to work at this point. It's really situationally based on the finances of the family. And Katie, which I didn't know if you also want to jump in on this as well.
Yeah, no, that's exactly right. One thing I wanted to mention when we're talking the 60 or 70% is that unfortunately the rate is set way too low, like where the break point is between those. So if somebody makes minimum wage and they work full time, they're still going to end up in that 60% category. So it's good to know that that 70% does exist, but for most folks, it's going to be 60%. But you covered it, Charlotte.
Okay, great. Okay, so let's go into the next scenario. Again, so this is going to be some questions and we'll ask in the chat. If there is a poll, let me know. Thanks, Kim, for letting me know. But this will be all in the chat. So Simone, she's a new mama. Simone is expecting her first baby. She has about 10 coworkers. She works 20 hours per week and has been at her current job for a year. She looks at her paycheck and she can see that CASDI is being taken out. So here's a few questions, and if you don't know, that's fine. Just test yourself. Based on what we know with the 10 co-workers, 20 hours per week, 1 year at the job, and she does pay into CASDI, does she qualify for pregnancy disability leave? Does she qualify for paid family leave for bonding? And would she qualify for job protection while on bonding leave? I see a couple yeses, a few yeses. All right, let's go to the next slide. Good job. So this is a bit of a tricky one. It is yes and no. So good job. So Simone qualifies for pregnancy disability leave because she is a pregnant worker, just like Katie said earlier. She's pregnant and she works for an employer of 5 employees. So this means with pregnancy disability leave, this can typically last 4 weeks before the estimated due date and 6 to 8 weeks after an uncomplicated birth. And during this time, she would receive partial wage replacement through state disability insurance, and she pays into that. And she does qualify for paid family leave for bonding because she pays into the state disability insurance fund. Unfortunately, Simone does not qualify for job protection. She only meets 2 of the 3 requirements. So she is taking time off to bond with her baby, and she works for an employer with 5 employees and has been there for more than a year. But unfortunately, she doesn't work enough hours. She has only worked 1,040 hours in the past year, which is fewer than the 1,250. So let's talk about this a bit more. Again, the Cifra writes 1 year in the job, 25 hours a week, employer with 5 or more employees. And then, so we're gonna have 2 visuals here. This first slide will be Simone's case of not being eligible, and then we'll go into a worker that is eligible. So again, here's what we're gonna look at. At the bottom will be for job protection, and at the top will be the wage replacement part. For a pregnant mama, she's going to start with her pregnancy disability leave and her state disability insurance. So as you see here, 4 weeks for pregnancy and then 6 to 8 weeks to recover. Then she would transition into pregnancy paid family leave. That application will pop up in her SDI account to apply for it. Unfortunately, when we see the 12 weeks of job protection to bond, she doesn't qualify for that. So what we would recommend is to have a conversation with your employer if you can still take this time and have your job when you come back. And I thought, Katie, if maybe you wanted to touch upon this a bit more.
Sure. So yeah, if someone doesn't have the 1,250 hours before, that means that their employer is not required to let them take that time off. But this is where it's important to remember that you can take the 12 weeks of bonding time anytime within a year of when the baby is born. So if Simone decides to go back to work, and after working for a while, she gets to the point where she has 1,250 hours within the last year, she would be able to start her bonding leave then. So it might be later in the year, but she could still take it. Another thing I'll throw in is that you know, for a lot of babies and parents to have to go back to work after only 6 weeks or after only 8 weeks. That's a really short amount of time. So some healthcare providers are conscientious of that in their determination of if somebody needs additional time to recover from childbirth. So like we talked about pregnancy disability leave, there's no hour requirement, there's no tenure requirement. The only requirement is that the healthcare provider says that they continue to need time off to recover from childbirth. So if somebody's in the circumstance where they don't qualify for the 12 weeks of bonding, it's always good for them to talk to their healthcare provider about their concerns and their stresses and see if there is a medical reason that they would need additional time for their health. Because that pregnancy disability time, it's all about the employee's health, not the baby's health. But if they need more time for their health, then they could take additional time off and have their job be safe and continue to receive that same income from state disability insurance.
Great. And I just wanted to know, oh, sorry. Yeah. And just wanted to add one more thing for this one, when it does say you ask your employer and you're having this discussion, because unfortunately, you know, Simone doesn't qualify for the job protection at this point. When you're having this conversation with your employer, make sure you're documenting everything, you know, sending an email outlining what you talked about. And if your employer did agree to taking this time and making sure you have your job back when you return, it's best to always document all communication. So on the next slide, and this is just, you know, very quite similar to the last slide, but this is for a pregnant worker that is eligible for Cifra. So again, pregnant worker would start with her pregnancy disability leave and state disability insurance for wage replacement, transition into PFL, and then also transition to Cifra after pregnancy disability leave. So this is really just a visual of how these laws work together in the transition for mamas from pregnancy disability leave to Cifra. And before we go into the next slide, Katie, I didn't know if you had anything else to this.
Yeah, I mean, you covered it. I wanted to add one thing to the talking to your employer that you mentioned in the last slide and documenting it. It's important to give the employer any medical notes. They don't need to have details. Just say that someone's, you know, disabled by their pregnancy and can't work. And I also just wanted to say that, like, documenting it doesn't have to be anything like formal or threatening. Like, if somebody has a talk with their manager and says like, hey, I'm going to need this amount of time off, and the manager says, okay, yeah, you can take this amount of time off, you know, come back on this day. Even just following up with a text and being like, hey, thanks for talking with me earlier. Like we discussed, you know, I'm going to be out for pregnancy and for bonding with my baby from date until date. So it doesn't have to be a formal letter. It doesn't have to be anything scary. It's just like saying, hey, this is what we talked about, so that if somebody remembers something differently later on, there's at least, you know, some record of what that conversation was. And that can be an important thing to do, whether somebody qualifies for pregnancy disability leave in California Family Rights Act or not. Just making sure that the employer and the worker are on the same page, and that, you know, somewhere in writing, there's something showing that, you know, the employer knows the reason that the worker's out of work, and they know when that person's planning to come back.
Great. Thanks so much, Katie, for that. And actually, I'm going to pass it back to you so we can go into paid sick and safe days.
Okay, great. Thanks, Charlotte. So in California, we do have a paid sick days law that allows people to take time off from work. And unlike the other laws we were talking about, it protects somebody's job and also allows them to get paid at the same time. So in California, if someone is working for their employer for 30 days, they start accruing these paid sick days, this paid sick time. And then once somebody reaches 90 days of working with their employer, they can use those paid sick days. Their employer can limit them to a total of 3 paid sick days per year, but an employer cannot, they cannot have it be anything less. And so they can be used for somebody's own illness, if they're sick, if they have to go to a medical appointment, if they have to take a child in. It could be to get vaccinated or for a checkup. But they can also be used for domestic violence, sexual assault, or stalking. So if somebody needs to go to court to get a restraining order or to seek services from a shelter or a crisis center, those are also reasons that somebody can use their paid sick days to get that time off and be paid. So as far as what those days look like, they offer 100% of your regular pay. The employer has to hold your job and can't hold it against you. Employers are not allowed to say no. They're not allowed to require a medical note. And it's important to give your employer notice if you can, but if it's something that comes up where you can't provide notice, that's also fine. And then your employer is not allowed to say, hey, you only, let me know about this yesterday. If you got sick yesterday, that's perfectly fine, and you can use it that way. So as far as, what your employer can require, they can't make you find somebody to cover your shift. They can't require a doctor's note. And it's up to you to decide how much paid sick time you want to take. So, if you want to take an hour off or 2 hours off because like you have an appointment in the afternoon, your employer's not allowed to say, hey, just take the full day. If you want to work for part of that day, you have the right to do that. And so just one other thing I wanted to mention on the DV sexual assault and stalking front is that there's a separate set of laws that allow somebody to take time off or to get accommodations at work to keep them safe if they are experiencing domestic violence or they're a survivor of domestic violence or sexual assault or stalking. So I'm happy to circulate resources afterwards. And if you have questions, feel free to reach out to me. But these paid sick days are an important tool, but beyond those 3 days, if somebody needs more time, there are other protections that are available. But it's too much for us to cover in one training. So I also want to share COVID-19 supplemental paid sick leave. So this is a new protection, but it's a really important one because this is what lets workers who, for some reason, it's not safe for them to go to work because of COVID, to take that time off, know that they'll get their full income, and know that their job will be safe. So the reason somebody can use supplemental paid sick leave are for reasons related to their health. So if you are quarantining or in an isolation period because of exposure to COVID-19, if a healthcare provider has ordered you to quarantine, or you're experiencing symptoms and seeking a medical diagnosis. So, if somebody has a runny nose or a cough, they don't need to have a COVID-19 diagnosis. They just need to be seeking care. Because the idea is we don't want to force people to go to work if they might be contagious and they might get others sick. We want them to stay home and to get paid so that they're not having to make that choice of, can I afford to go without pay, or should I risk it and go to work? They can also be used to take care of a family member. So if a family member is subject to a quarantine or isolation or has been advised by healthcare providers to stay home, that's a reason that somebody can take this time. And also to care for a child whose school or place of care is closed or unavailable. This is limited to a closure that is due to COVID-19 on the premise. So it's not like if a school has been closed, all the way back since last March, but if somewhere has reopened and then closes again because maybe a child comes in with COVID-19 or somebody's exposed, that's a reason somebody can use these paid sick days. And then finally, they can be used for vaccines. So that can be attending a vaccine or recovering from a vaccine. Because, you know, similarly, the state doesn't want people to choose not to get vaccinated because they're worried that they can't afford to take a sick day. So also important is, you know, what does this provide? And so what it does is it gives someone 2 whole weeks of fully paid leave where their job is safe. The one limitation on who qualifies is that they have to have an employer that has more than 25 employees. So if somebody has a smaller employer, they won't qualify for this, and they'll need to look at other protections like the normal paid sick days that we talked about, or even the California Family Rights Act leave for a serious health condition that we talked about. So don't think that if someone works for a smaller employer, they don't have any options. It just might be more complicated, but they should still reach out to us or go to the labor agency's website or seek guidance, because there might be a way that they can still take time off and be paid. So this only was signed on March 19th, so it's pretty new, and it started on March 29th, and it'll be available through the end of September. But it's important to know that from the start of January of 2021 through the end of March, there was a gap in COVID-19 paid sick leave. Basically, when 2021 started, all of the existing paid sick leave laws related to COVID-19, they just expired, because when people put them into place, they thought, oh, you know, this is going to be done by the end of 2020. And as we all know, it wasn't. So what this law does is if somebody had to take time off between January and March, and their employer did not pay them for that time off, they can ask their employer to pay them, and the employer is required to at the end of their next pay period. And so this is totally separate from any COVID-19 paid sick leave in 2020. So if somebody took off 2 weeks in 2020, that doesn't impact their ability to take more time off in 2021. And this is in addition to those 3 California paid sick days. So the idea is that, you know, even if you're exposed to COVID-19, it doesn't mean you're never going to get a cold or have a doctor's appointment. So somebody can take these 2 weeks and save those 3 days that they have, if they're able to, for family and their own appointments later in the year.
So I thought we'd do a couple poll questions. So Kim, when you saw the last one, this is where it was meant to be. So sorry to alarm anyone. So for the first poll question, true or false, based on what we just learned with Katie, can you use paid sick and safe days for preventative care, to seek care, or seek care from domestic violence prevention services? All right, so I can't see the poll, so we'll go to the next slide. So if you picked true, it is true. As Katie covered, you can use paid sick and safe days for preventative care. So if you want to go get a checkup, get a vaccine, it's good to go for that. And also to seek care from domestic violence prevention services. Like you said, Kim, in the chat, this is very important, because ladies do often walk off the job not knowing their workers, right? So, you know, spread the word. This is also for domestic violence prevention. Next poll question. So question 2, true or false? Paid sick and safe days do not offer job protection. Employers can legally deny you paid sick and safe days. You guys can see the poll, right? Sorry, I can't see on my end. Okay. All right, let's go to the next slide. So false. Paid sick and safe days carry job protection. To qualify, you must be employed for at least the last 90 days, worked in the state of California for 30 days, and have accrued the right amount of times to take this leave. So employers cannot legally deny requests for paid sick and safe days. Kay, I didn't know if maybe you wanted to jump back in about ensuring your rights, and then we were going to talk about some of Legal Late at Work's resources about communication.
Yeah, of course. So one thing I wanted to add just on the domestic violence and paid sick days front. So one of the things that we talked about was how if you're taking less than 3 days, your employer can't require a medical note if it's those 3 California paid sick, paid safe days. So sometimes, I'm talking with somebody and they need time off for a reason related to domestic violence, and they don't really want to tell their employer about it. Because you can't be required to provide a certification for those 3 paid sick days, somebody, if they're more comfortable, they could say, I'm sick today, I need to take one of those 3 paid sick days, and the employer can't require a medical note. So, if the issue is, somebody has a black eye that they don't want someone to see at work, or they're nervous about it, I mean, it's against the law for their employer to discriminate against them because of it. But they could also say, I need to take a paid sick day. They don't need to give their employer the details of the reason that they need that day off. So as far as the ways to protect your rights, number one for all of these is to talk to your doctor or your healthcare provider. So to be able to take time off for your own serious health condition, for pregnancy disability leave, you're going to need a medical note. And for COVID-19 paid sick leave, like we talked about, for quite a few of the reasons that you can take that, you're going to need a doctor's note or a doctor saying that you need time off as well. So once you have that, it's important to also talk to your employer, because these protections are in place if your employer knows the reason that you are taking that time off. If you never tell the employer and the employer doesn't know it's because someone has a serious health condition, the employer can treat it just like any other absence. So it's important to communicate it. In the state of California, nobody needs to provide a diagnosis to their employer, but it's important to let them know, it's something related to pregnancy, or it is a serious health condition, or it is to bond with a new child, generally kind of the category of it. And if someone has questions about like what specifically to share or not share, we have sample notes, and they're also welcome to reach out to us. The third step, obviously, is to think about the income part of it. So contact the EDD, apply for those benefits, make sure that someone's going to get paid during it, and then document the communication. So, if you have a phone call with your employer, follow up with an email or a text or just something saying, hey, thanks for talking with me about this. I really appreciate it. Just so that, if somebody isn't paying attention or changes their mind, there is something you can point to say like, hey, I let you know that this was because I'm pregnant, that I needed the time off. And the employer can't say, oh, I thought you had a cold, I had no idea. So on our website, we have sample requests for time off for pregnancy leave as well as for bonding leave. And so when somebody makes that request, they don't have to, cite the law to their employer, but it can be helpful to let them know kind of generally, this is about pregnancy disability leave, or this is the California Family Rights Act. Because what it does is it kind of puts the employer on notice and can encourage them to look it up on their own if they don't know about those laws, that this isn't somebody asking for a favor, this is somebody who's asking for a right. So feel free to check out our website to see those sample letters.
Great. Thanks, Katie. And I do encourage you, Legal at Work resources are really great. You can download them and it has directions how to fill it out. So for our resources at the coalition, this is what we're going to go into for our next scenarios, is the paid family leave checklist. So this helps us understand eligibility. It's really everything that we discussed, but into a simple one pager for us. So yes, next slide. Thank you. So for the first scenario, we have Devon, and he is planning to finish the application process to become a foster parent and wants to know his rights to take bonding leave once his child is placed with him. He works in San Diego. He has worked at his job for about 5 years. He works full time, so 40 hours a week, and has about 40 coworkers. So in the chat, what is the first step to know if Devon is eligible for paid family leave? So what would we have to check to know if he is eligible to take paid family leave? Amount of hours worked, length of time on job and hours. Those are good guesses, and that is close. We do need to know those. But for the next slide, so the first step is to know if he pays into CASDI. So all the things that was said in the chat, those are still very, very important to know. But for paid family leave, to know the eligibility is to if he pays into CASDI, and if he doesn't know, let's ask him to check his pay stub. So we check his pay stub and we see it on there, California State Disability Insurance, so he pays into the fund. And then the next step is to use a checklist and figure out everything that everyone said about hours worked, number of employees, and time on job. So the checklist. So these are quite a few questions. So the first one is, why are you using this time off? Are you using it to time off to bond as a birth parent with a child born within the last 5 months, bond as a non-birth parent with a child born within the past 12 months, bond with an adopted child within the past 12 months, bond with a foster child placed in your home within the past 12 months, and then the last one is caregiving for a seriously ill family member. So for Devon, it would be bond with a foster child. And then, so have you worked at your job for at least 1 year? Yep. Have you worked at your job for at least 1,250 hours? Yes. Does your workplace have 5 employees or more? He does. And do you pay into CASDI? So this is why we kind of asked him to check real quick before we started the checklist, just so we know that he does. And then, do you work for the city of San Francisco? Before we go into the next one, Katie, I don't know if you want to jump on this. So we asked this question because the city of San Francisco has a local ordinance for the San Francisco Paid Parental Leave Ordinance. And Katie, I think you would explain it better than I could.
Sure, I'm happy to jump in, although I know you would explain it beautifully. But in San Francisco, there's a law where if you are working 40% of your hours at least, and that's at least 8 hours in the city, on top of whatever you get in paid family leave, your employer has to top it off to make sure that you get 100%. So for those 8 weeks of baby bonding, your employer, if you get 60% from the state, your employer has to pay that top 40%.
Yeah, thanks, Katie.
And I see a question in the chat from Kristen about if there's a way to find out if your job pays into SDI before you gain employment there. I don't know of a clear way to do that, but basically every private employer does. Like, there's a requirement in the state that if you're a private employer, either your employees pay in, or there's like a rare exception where if you on your own as an employer provide like a separate benefit that's equal to it, you can use like some other private agency to provide that benefit that is at least as generous as SDI. For people who are applying for a job, working for like a county or a city, that might be a place where when they are applying, they could ask. But if it's a private employer, it's pretty much a guaranteed yes.
That's actually a really great question. I have never even thought of that question myself. I see another question. I'm going to finish up the scenario real quick, and then we can talk about when he should give notice for leave, because that's really great as well. So next slide. So he does qualify like we talked about, and let's talk about this a bit more. So here's why. So as we talked about, he qualifies for paid family leave for bonding because he pays into CASDI. So this means he can take up to 8 weeks to bond with his foster child placed in his home within the first year, and receive 67% of his pay. And he meets the qualifications for Cifra of 1 year on the job, 5+ employees, and 25+ hours a week. And I don't remember if there's this next slide for this one. Could we check real quick? Okay, so let's go back to the last one. So in this scenario, when should he give notice for leave? I feel like as soon as possible. Katie, if you could jump in on this. I'm not sure about how the foster care system works, if when you would get notice when your child is placed, but Katie, I might hand this question off to you.
Yeah, so if you have the notice, your employer can require 30 days, but like if you don't have 30 days notice, then just as much notice as you can provide. So it just depends on the circumstance. But like if it's something outside of your control, they can't hold it against you that you can't provide 30 days notice.
Great. Such great questions. Thank you. All right, let's go into another scenario. So this one's a bit more complicated, but we did want to walk through this. So Naomi and Tiana are expecting their first baby. Tiana is 25 weeks pregnant and wants to know her and Naomi's rights to take leave to bond with their new baby. Naomi has worked full-time, so 40 hours per week for an employer for the past 5 years and has 20 coworkers. Tiana has worked 30 hours per week at her job for the past 2 years and has 60 coworkers, and both of them pay into the CASDI fund. So for this, when you're working with parents, let's start with the pregnant mama, since she will be taking her disability first. So Tiana is pregnant, so she needs to see if she meets eligibility requirements for pregnancy disability leave and state disability insurance. So does Tiana qualify for pregnancy disability leave, and does she qualify for state disability insurance? So let's look into that. So Tiana meets the eligibility requirements for PDL because she's a pregnant worker and she works for an employer with 5 or plus employees. She meets the eligibility requirements for the state disability insurance, which is where she'll get her wage replacement at this time, because she pays into the fund. If she has an uncomplicated pregnancy, she is likely to take 4 weeks of job protected time before her birth, and then 6 to 8 weeks after the birth. And she can receive up to 60-70% of her wages through the state disability insurance. So now let's see, now that we know Tiana's eligible for pregnancy disability, let's see if Naomi qualifies for bonding leave. So again, we go with the first question, why are you using this time off? And so for Naomi, she would check bond as a non-birth parent with a child born within the past 12 months. And then based on the information she gave us, have you worked at your job for the last year? She has. Have you worked at least 25 hours a week? Yes. Does your workplace have 5 employees or more? Yes. Do you pay into CASDI? Yes. And unfortunately, they do not live in the city of San Francisco. And then again, just the Cifra writes that she met the 1 year on the job, 25 hours a week, and 5 or more employees. So for Naomi's rights, based on her responses, she does qualify for paid family leave for bonding and job protection. So she qualifies because she pays into the SDI fund, and she qualifies for job protection because she met those 3 requirements. So now that we know Naomi's rights, let's also note Tiana's rights for bonding leave as well. So for Tiana, why are you using this time off? She is going to bond as the birth parent with a child born within the past 12 months. She has worked at her job for at least 1 year. Have you worked at your job for at least 25 hours a week? Yes. Worked at with a workplace with more than 5 employees? Yes. She does pay into CASDI, so she would click yes there. And then she does not live in the city of San Francisco. So for Tiana's rights, she can use paid family leave for bonding and receive up to 8 weeks of partial wage replacement. And she does meet the job requirements, job protection requirements, and can take up to 12 weeks of unpaid job protected time off to bond with her baby. So let's visualize all of this together. That was a lot of information and a lot of good rights to access. So let's start with Tiana. She's the birth parent on week 1. So this is about 4 weeks before she gives birth, estimated, right? Birthing can happen at unexpected times. So Tiana's pregnancy disability would start about 4 weeks later. Tiana had a C-section, and her pregnancy disability leave would still continue through this as she is recovering from the C-section. At this point, when she gave birth, Naomi decided to start her bonding leave then. And then about 8 weeks later, Tiana's pregnancy disability would end. And at that point, her bonding leave application would be in place. She can fill it out and take bonding leave and to start. And then while Naomi's bonding leave ends, to note that though Naomi's bonding leave does end, the 8 weeks of paid family leave, she still has 4 weeks of unpaid job protected time off. And it's really up to their partner and the parents. Does Naomi go back to work? Are they financially stable? Or does she use the unpaid time off? So it's really just to think about that. But for this, Naomi's bonding leave ends, and let's assume she goes back to work, and Tiana's bonding leave starts. And then 8 weeks later, Tiana's bonding leave ends. And then again, she has 4 weeks of unpaid time off. And essentially, every scenario really is very specific to each partner and family and individual. But this is just to show you how these laws could coincide together as with 2 partners, with a birthing parent and a non-birthing parent. And Katie, I don't know if you want to add a bit more to this timeline.
I think you covered it. Thanks, Charlotte.
Okay, great. Yeah, great. So Tiana and Naomi's rights is that they decided to take time off when they receive wage replacement and job protection. They both can choose to use the additional 4 weeks of job protected unpaid leave to bond with their new baby. So one thing I want to note when you're working with, whether it's caregiving, bonding, any family, is really just letting them know, their rights and letting them consider the financial part of it. Can you take this time off, the 60-70%, the part that could be unpaid, when they're planning for this, right? Just so they can keep it in mind and make good informed decisions that can help them take this time off, bond with their baby, but also make sure they're supported financially. So before we go into some Q&As, last training session, we had some frequently asked questions, and I thought I could go over them real quick. So FAQ 1, does an employee have to work a minimum number of hours or days before becoming eligible for PFL or SDI benefits? So no, as we have covered, it's not about the number of hours or days you work to be eligible for paid family leave or SDI benefits. Is the amount of benefits you receive determined by your earnings during the base period? So you can also calculate this on the EDD website. I'm going to share a resource real quick in the chat. So this is a calculator in the EDD website, and this can help you estimate the benefits that you would receive when taking leave. Next slide, please. So can my partner and I both use paid family leave to bond with a new child? Yes. So like that we covered with Tiana and Naomi, yes, both parents can use paid family leave to bond with a new child. You and your partner may, but do not have to use it at the same time. Like I said, this is situationally based. It's best to know both parents' rights and evaluate what would be best for both of them and as a family unit. Next, please. So, what is considered a serious health condition under paid family leave, Cifra, and FMLA? So, commonly, a serious health condition covered by these laws is one requiring an overnight stay at the hospital or a medical care facility. Two, that you're incapacitated or a family member is unable to attend school or work for more than 3 or more days, requiring ongoing treatment. This is like doctor's visits or prescription medication. And then finally, chronic conditions that can cause periodic incapacitation. This is such as migraines and asthma. So those are just some of our FAQs. We'll share more resources, but I thought at this time we could have some questions, some Q&A.
So I see a question of whether you're eligible for PFL if you are unemployed or collecting unemployment. That's a great question, especially now. And so you can be. The question that the Employment Development Department asks is, except for the fact that either you're disabled from working for state disability insurance, or you are bonding with a new child, or taking care of a seriously ill family member, would you be a part of the labor market? So that means, would you be working or would you be looking for work? So if you would be looking for work, or you would accept work if it was presented to you and you got the job you were applying for, you'd take it. Except for the fact of the bonding, you can still qualify for paid family leave. As far as I can talk a little bit more about that base period again, because you do need to have paid in that base period. And it's kind of confusing, but basically they divide the year up into 4 quarters. So what you do is you look at the current quarter of the year, cancel that one out, cross it out, it doesn't matter. Look at the quarter that led up to this, the one beforehand. So like right now, it would be January through March. Ignore that one also. But then look at the 4 quarters that led up to that. And then, did you earn at least $300 in any of those 4 quarters? And what the EDD will do is they'll look at whichever one of those quarters you made the most money. So if somebody, had a job in the beginning of 2020 and they lost that job in March and they wanted to apply for paid family leave right now, they would potentially be able to get it because their base period would be all of 2020. So even though they didn't work in the second quarter or the third or the fourth, because they did in that first quarter, they would have income that the EDD could look at. So the second question I see is, are gig workers eligible for any benefits? So that's a good question. People who are independent contractors do not pay into state disability insurance or paid family leave. So if they didn't pay in, they would not be able to qualify. Unless, like, let's say they had a job as an employee that was within their base period again. So like if somebody's been working as like a Lyft driver since April, but in January through March, they were working as an employee, they would potentially be able to get benefits. Also, I'll say, like, there are a lot of people who their employer says that they're a contractor because they don't want to have to pay those benefits, but they are employees. So if somebody's in that circumstance, like they are acting as an employee, they're working for this one employer all the time, but their employer says, no, you're a contractor, there might be a way that you can still get those benefits, and they can feel free to reach out to us and we can help them figure that out, because it's more complicated than it should be.
And this is Jenya. I think also one of the things that the EDD often says to us, which, you know, might seem a little counterintuitive, is just that, you know, if people worked in the last X amount of time, like in the last year or so, but they're not working now, or if you have a job for whatever reason, you're not paying into paid leave, which would usually be a gig job or a public employee, if you let them make the determination. So sometimes, you know, it doesn't hurt to apply, but you don't always know ahead of time. There's a period of time. I don't know, Katie, if you know the amount of time. For example, I literally left the country. When I came back, I was unemployed, but I was also about to give birth to my first child, and I did qualify to take SDI for pregnancy, you know, disability. And it had been a while, and I was surprised. At the time, I didn't work in this field, and I didn't know much about it. I don't know, Katie, if you know how long back they look, or if it's just applying to see if you can get the paid leave.
Yeah, so it's that rule of thumb of don't look at this quarter of the year, don't look at the quarter before it, but look at the 4 leading up to that. There can be like special circumstances where you can ask them to like look at a different base period if something specific happened, but generally it's going to be what we talked about, which is, you know, about 4 to 18 months in the past. So yeah, if somebody's not sure, it doesn't hurt to apply.
Hey, so I think we have time for a couple more questions before we wrap up and talk about a couple more things. So go ahead and put them in the chat, or you can unmute yourself. If not, we'll continue the presentation, and if at the end there's more questions, oh, there is one question. Is there a way for gig workers to pay into the program? I think, Katie, there's a way to opt in or ask to pay in, correct?
Yeah, there is a version where you can say you want to pay in and pay into the program. It's not especially well designed, and because it's not very well used, before someone chooses to, they should take the time to carefully kind of like look at what it costs and what they would get back, because there are circumstances where someone might pay into it and not get as much out as they paid in. But you know, if they are going to have a baby, so they know they'll need time off for pregnancy disability, and they know they'll need time off for paid family leave, it is a possibility. And I'll pass it to Jenya too, because I know one of your team members like wrote an article kind of about her experience of looking into that can be a helpful reference.
Yeah, thanks, Katie, for remembering that, because I just put it in the chat. Allison Guevara, who worked with the coalition and is still a member of the coalition, wrote this really the most comprehensive guide that is a lot less confusing than what the EDD has on their website, although it does link to it. But yeah, so it kind of gives you all the ins and outs, and a really good way of assessing, is it worth it? Because there are contractors that are legitimately contractors but you kind of have to plan ahead to opt in, is the main takeaway. But yeah, so check that out, because it's just a great guide to anybody you know who's a contractor and thinking of opting into SDI and paid leave.
So I see another question. I'm happy to jump in. So if an employer can extend job protection past 12 weeks for FMLA as an accommodation. So in California, we do have a law called the Fair Employment and Housing Act, and it's basically like a state equivalent of the ADA, the Americans with Disabilities Act, if you've heard of it. And so what it does is, if someone has a disability, it requires their employer to, if that employee makes a request for a change at work or an accommodation that would allow them to continue working, their employer has to consider it and provide it unless they can show that it'd be extremely difficult for them to do it. So, it could be reduced hours, it could be sitting instead of standing, but it can also be additional time off so that you're able to recover and then go back to work. So the important thing to remember is that it's not that same 100% your employer has to provide that time and you can come back and your job is, the same as it was, and they can't hold that time against you. Instead, it's this balancing act where they have to hold your job unless it would be hard for them to do so and they can show that it'd be really difficult. So if somebody is in that circumstance where they need additional time off for their health, it's a little bit more complicated. So I'd suggest they give us a call just to get some tips. Because, like, for example, if you give your employer a note saying that you're going to need 3 months off from work, it's a lot easier for your employer to say that's too hard and that they can't do it, as opposed to if you give them a note saying you need 1 month and then your employer has to say, okay, it's only a month, like we can make it work. Later on, you might give them a note asking for a second month. And again, your employer has to be like, well, okay, it's only another month. And so basically, depending on how you ask for that accommodation and ask for that time off can make a difference in whether or not your employer is required to provide it to you. But yeah, it's really important to remember that if the reason you need time off is because of your health, there's never an endpoint where your employer can say, I have no more responsibility for you. I'm going to fire you. You're outside 12 weeks. We're done talking. Instead, it moves into this territory where they still have obligations, but it's just a little bit fuzzier.
So thank you all for great questions. I'm gonna have we have a few more slides to cover just to wrap it up. But if anyone has more questions at the end, I'm happy to stay on. We're happy to stay on just to answer a few more. So if we could go back to the presentation.
Sorry, 1 second.
No worries.
Trying to find my tab. Okay.
Great. Alrighty, so like last week, we have resources here. If you want a better understanding of paid leave, Legal Aid Works resources, the EDD resources down there, and then on the next slide, we have a few more resources regarding paid sick and safe days. There are local ordinances that have stronger laws. So we have some resources regarding that. And of course, the supplemental paid COVID-19 supplemental paid sick leave, and then some childcare resources that were requested from the last training as well. And just like last time, if you need free legal advice, the Public Counsel Law Center in LA serves women workers and students who are experiencing discrimination, sexual assault, pregnancy, lactation, family medical leave, and COVID-19. And then tonight, this is super exciting. Tonight at 6 p.m., the community support person application is launching. So please read through everything very carefully, but this position is an estimated 10 to 15 hour commitment from May 3rd to June 25th. There will be 10 positions available. Applicants must complete the 3 hours of the virtual training session. So if you attended last week and this week, you're good to go. There will be 3 requirements. So on that page, I will send everyone a link. So tonight at 6, look at your email. I'll send everyone a link to the application. Please read through everything carefully. And this application will be open till next Monday, April 19th at 6 p.m. So just watch out for my email. And with that being said, thank you so much. I know, Mia, I think you had a few words to say as well.
Yeah, I just wanted to say thank you everyone for showing up for yourselves and your community. And I also wanted to let you all know that you should follow us on social media and Legal Aid at Work. We have great resources and content that we share on our social feeds, as well as action alerts. So if you're interested in raising the wage replacement rate, or improving paid leave in other ways through legislation. We talk a lot about that on our platforms as well. So it's a great way to stay notified and up to date. And then also, as you can see, our website links are here. workfamilyca.org is our website, the coalition, and then legalaid@work.org/WF is where you can get a lot of those great downloadable resources and guides.
Great. Thank you so much. So yes, follow us and connect with us and stay connected. And thank you so much, everyone, for joining. This has been a pleasure.